Today, we will be looking at the area of intellectual property rights. Intellectual property rights can be broken into two categories: soft intellectual property rights and hard intellectual property rights. Soft rights, such as copyright or trade secrets, are rights that occur automatically and consequently do not need to be registered. For example, if a person writes a book, they are automatically considered to hold copyright over their creation. The primary problem with soft intellectual property rights is that if infringed in any subsequent action before the courts, the burden of proof will be on the party claiming ownership to prove that they are indeed the owner. Hard intellectual property rights, such as patents, are rights that are registered with the appropriate authorities. Once a right is registered, it remains inviolable for the period of protection awarded. Consequently, the burden of proof as regards any future dispute as to ownership rests not with the registered owner, but with the party contesting the validity of the registered ownership. Outside of this broad characterization, there are, as we have seen, specific categories of intellectual property right. The first is copyright. Copyright protects original creative works of authorship, for example, literary and written works like a novel or website content. In order to be capable of protection, the work must physically exist. One cannot receive copyright protection for an idea. As we have seen, copyright protection can occur either by way of a soft or hard intellectual property right. Copyright lasts for different lengths of time depending on the jurisdiction concerned and on the work being protected. In the United Kingdom, the protection offered is as follows. As regards literary, dramatic, or artistic work, the work is protected for the creator's life and 70 years thereafter. For broadcasts, the broadcast is protected for 50 years from the first date of broadcast, and for sound recordings, the sound recording is protected for a period of 70 years from the first date of publication. Next, we will look at design rights. Design rights automatically protect the physical shape of an original design. For example, a vase with a unique shape is automatically protected under UK design right law. The design must be unique and cannot be commonplace. Design rights protect a creation until the earlier of the following two events. First, for 15 years after the design was first created, or alternatively, 10 years after the design was first marketed and sold. Next, we will look at patents. Patents exist to protect inventions. In order to be patentable, an invention must be either new or alternatively be a non-obvious modification to something that already exists. One cannot patent literary, dramatic, musical, or artistic works. In the UK, a patent can last for 20 years from the date of application. Next, we'll look at trademarks. A trademark is used to reinforce brand recognition, for example, a logo or a sound. Registering a trademark prevents other people from using the trademark without permission. The trademark registration lasts for a period of 10 years. However, it can be renewed indefinitely every 10 years. Finally, we will look at trade secrets. Information coming under the heading of trade secrets includes information such as customer lists, where they cannot be ascertained from publicly available sources, manufacturing details, special recipes, etc. When considering whether information amounts to a trade secret, the court will look to issues such as the availability of the information. Clearly, it must be a secret, and the level of difficulty associated with its acquisition. The second issue is whether it's known by employees, and if so, whether the employees concerned have been required to sign non-disclosure agreements, referred to as NDAs. If they have not, the courts might very well consider that a sufficient effort has not been made to keep the information secret. Finally, the court will look to the amount of investment represented by the acquisition of the information. Now we will take a quick look at the relationship between intellectual property law and contract law. In reality, to a large extent, there is no natural relationship between intellectual property rights and rights established under contract. The two are fundamentally different. Intellectual property rights are a state-vested system, whilst contract rights result from party choice relationships. Thus, the primary role of contracts in the area of intellectual property is to convert state-vested intellectual property rights into party choice rights, i.e. for a party who has a right to transfer it by contract to another. If an intellectual property right is violated, both civil and criminal jurisdiction may be triggered before the appropriate national courts. If a contractual right is violated, the resolution of the dispute is confined to the area of civil law, and a method of resolution will normally be set out in the contract, for example by way of arbitration or by a state judicial mechanism set out in the contract. We hope you enjoyed this introduction to the area of intellectual property.